All right, we are recording. We're here deliberating in the matter of Greenspring Manor, 2310 West Joppa Road, CBA 22-027, which is a appeal of an approval of a forest buffer variance pursuant to 33-3-106A1. We also have the matter of CBA 22-028, which is the appeal of the forest buffer analysis pursuant to 33-3-112C. For housekeeping matters, originally there was CBA 22-029, which is a forest conservation variance. There was a motion to dismiss based both on timeliness of appeal and also the fact that the forest conservation variance was a topic that would be covered during a development plan hearing. Notable that there hasn't been, well, as the time we reviewed this case, there had not been a development plan. I believe that's still to take place. This is just dealing with the forest buffer alternative analysis and the variance relief. So that is where we are starting. Just to revisit, gentlemen, there was the motion to dismiss that was based on the timeliness of the appeals. I believe at the time of the hearing, we considered it and talked about the language that was actually in the letters, which said things like our intent to approve and contingency of things signing off from the actual developer. I think it was our finding at that point in time that that language kind of hinted at the lack of finality, and that was not the operative letter that was timed for appeal. I remember that was my thought on the matter. I remember thinking to myself, it would be nice if someone from the county could tell me when they decide when the appeal time starts, but we didn't have such testimonies. So we were basically dealing with the four corners of the correspondence themselves. I know it was my determination that at least in this matter, it might change in future matters, but in this matter, and the evidence was presented as, I was looking at it as sort of a civil rule of lenity, in that basically the way the language was there should basically give the protestants an opportunity to pursue their appeal due to the fact that that language of intent was used. And that was my thought. Any further thoughts on that matter from you, gentlemen?
Well, I didn't really, I mean, I agree, except that I don't think we need the rule of lenity. I mean, I just think it's language of the letter is the language of the letter, and it's contingent. And so we denied the motion to dismiss, and I'm quite comfortable with that.
Okay. And Mr. Sampson, that's still your thoughts on the matter?
Yeah. What is the rule of, what are you calling it? Rule of what?
Well, in criminal matters, the rule of lenity is that if there is some kind of vagueness in a law, that you give the defendant the break, because if it at all can be in his favor. So I don't think there is a civil rule of lenity, but it was my opportunity to use such a big word in this setting. So I did.
I learned something.
A tie goes to the runner. That's what it is. A tie goes to the runner.
Tie goes to the runner. Yes.
All right. Very good. I have nothing to add. Thank you.
I've often argued the civil rule of lenity. Anyway, my apologies. Okay, which brings us to the meat of the matter. The first issue being the 22-027, the forest buffer variance under 33-3106A1. Again, being the standard that we employ. This isn't the BCCR. This is actually the BCC. So we have the practical difficulty and the unreasonable hardship. Little factual basis here. The property at issue currently has no forest buffer variance because one was not needed until there was going to be a subdivision of this land, which triggered the necessity of having the forest buffer variance, and which has been explained to us that it's not really a forest buffer variance, it's sort of a stream buffer variance. We were told that there is a stream that runs through the property on the east side of the property, and also there's a floodplain that runs along the Joppa Road for the entirety of the property, which would then require the need for forest buffer variance for further development. presently there's a historical, an older home. It's called the Langford home. It's been there for about 80 years. And it's basically where that home is situated is what is already sort of impeding into the buffer itself. So the request, because there's going to be further development, a proposed 61 lots that would be dealt with in the development plan. As Mr. Evans asked in his last question, I believe, of this hearing was, is it true that if we had one more house that we would trigger this forest buffer? And the answer was yes. And that was actually in the petitioner's brief, that any further subdivision 1, 2, or 61 is going to require this forest buffer variance. The issue of practical difficulty and unreasonable hardship here is basically, in order for there not to be an infringement into this, guess you would have to raise the home. That would be what would be required. I mean, not required. That would be the fix if there was not a variance granted as to this. So,
or you could not develop the property.
exactly, or you cannot develop the property. Yes. Well, and then yes. So I'll start. Mr. Evans, you wanted to speak to the topic, sir, on this one?
Well, I mean, you know, there's no opposition in effect, and you know, I'm so I'm good with it. I don't want it to be interpreted as some implicit support for a 60 house development, but you know, under these circumstances, they want to develop the property. And you know, they need this variance. So I mean, it just seems to me that they're entitled to it, right? I mean, it would be a hardship to say they can't develop the property in any fashion whatsoever. So, you know, I go along with it. I just don't want to be understood as somehow thinking that, you know, 60 houses is appropriate.
Well, that's why I prefaced to say that there is a development plan that's coming down the road where that's going to be an issue. And your astute question before at the end of the hearing, I don't know if you recall it, but I remember thinking.
I don't know.
Well, I remember saying, yeah, for you, great question. That is a situation. What we're dealing with here is not that part of the situation that this would come to effect, even if there was to be one more house. And I guess basically, if you would have to, one choice, you can't develop the property at all. Second choice, you have to knock down the home. And also, as you stated too, in this situation, we heard from a county official, and we also heard from the petitioner's expert. We did not hear expert testimony in opposition there too. Not to say that it's required, and we could still find otherwise in lieu of. But I agree with you, Mr. Evans, for the reasons previously stated. Mr. Sampson, sir? You're muted, sir. I'm sorry.
I agree for the reasons that you both have said.
All right, so we're moving right along to the 028 case, and that's the appeal of the alternative analysis for road, utility, and stormwater situations pursuant to BCC 33-3-112C. In dealing with that situation, you have things that are prohibited to do into this type of buffer, and then there's the alternatives that are allowed if through an alternative analysis for such utilities, roads, and stormwaters. There's actually three kind of a checklist of things that they try to gear these alternatives to, which is, you know, erosion issues, water issues, and aquatic life and wildlife issues as the three factors. So those three factors through that site that I provided, there's actually three requests here for the alternatives analysis. One being there's the actual where the road goes into this development. The second being there basically needs to be a widening of the road because of the development itself. And then the third there is going to be a sewer line that isn't present at this point in time, even with the older home. So the three factors, with three requests that then were looked at through Debs and also through Mr. Canolis. There was actually, I think, a total of five. There was five different alternatives, starting with the road, not five for each, but starting with the road itself. There was five different alternatives. The alternatives range from keeping the existing road to the new house and then spinning off of it. There was another saying having no road at all going into Chopper Road, because let's be said, because of the floodplain, any incursion of any new road into that situation, or even the existing road, it's going to require an alternative analysis. We heard testimony that you couldn't have no entrance on Chopper Road because there's a requirement that you have two. There's a possible one in the back, I think, towards Mace Chapel, and then you would have to have that one. So that wasn't feasible. And then I think there was three different versions of where Mr. Canolis had placed a new road, and that road having a spinoff to the new development. There was different analysis that were considered due to elevation, possible flooding issues. There was locations of the road to keep it further away from the buffer for the stream. Finally, there was one that was agreed upon by the county, one of Mr. Canalis's. And without going into deep detail, as Mr. Evans had brought forth before, I only speak for myself. I am not a great expert in such things as alternative analysis. So often I have to defer and judge the testimony of experts who provide these things for me. Again, we don't have any alternative to the alternatives, meaning we didn't have expert testimony telling us that Mr. Canolis was wrong or that Mr. Coolis was wrong and there was something else that could be done. So we have to give a great amount of weight to our county folks with the Marzillo v. Call. We could find otherwise if we had reason to. I'm just saying that, and I am deferring somewhat to the expertise that's been provided to me, and there has been no alternatives to the alternatives provided. So as to the road location, I'm going to have to basically agree with what has been brought forth to me by Mr. Canolis and Mr. Coolis. Mr. Evans, any thoughts on the matter, sir?
Well, again, I agree with your view of the posture of the case. Again, now this part of the case is premised on a 60 house development. That's why they have to be concerned about this, access to Mace Chapel Road in the back and all this kind of stuff. If it was just a one house development, I don't think any of that stuff would be implicated here. But so once again, I accept what's been presented to us in the absence of any contrary information. But again, I don't want to be understood as somehow implicitly approving a 60 house development here. That's not my intention. I don't want to be cited for that. That's cited with a C. And I also am not an expert in this, far from it. I'm frankly, a little confounded about just procedurally, why an alternatives analysis is heard now in a vacuum. Would seem to me make more sense to be heard in the context of the actual development plan, or if there are zoning issues, that seems to me to be the point where the record could be fully developed, or more fully developed, but I guess that's not the way this works. So we are here with this situation, and I agree with your view, and so there you have it.
Right. Mr. Sampson, sir.
Yeah, I agree. I have a question to you, Joe. The two times that you've mentioned not wanting to be uh, interpreted as uh, endorsing a 61 home development. And you've sat on this board a long time, and I've seen in other cases how decisions of this board in the very specific context of that issue presented have been attempted to be used and called binding precedent. And we don't have to get into that because I completely disagree with that, and that's not before us right now. But educate me quickly. The issue of the development itself is not before us. So whether somebody misuses it another time, I just want to make sure I'm clear. That issue is not before us, and there is nothing that we rule one way or the other that approves or doesn't approve the development, correct?
Well, that's my understanding. Maybe Mr. Belt can elucidate, but my understanding is that all we've done here, or all we are being asked to do here, is approve things that provide preliminary steps to enable the developer to pursue his development plan. Whether that's approved or not, who knows? But
And if done correctly, that should be independent and stand on the facts and the applicable criteria for that development. Then whether it's properly or improperly cited, what's going to be said is, and look, the framework is already in place for the buffer and the alternative analysis, right? That's how that probably comes up.
right.
Okay, I just wanted to understand that, because I agree with how we're ruling and what we're doing, and I appreciate your based on your experience and how you know these things are used or misused, intentionally or unintentionally. I just want to get the context of it. So I don't have anything else to add.
But just without going deep into the development plan process, again, as you recall, the beginning of the development plan review before it has the hearing, it's a full review of the relevant county agencies who all have to offer their comments on the issues. The issues that we have here, I guess, could be incorporated in some comments from an environmental situation, because that's basically what the variances are. So there's a whole lot of other hands that will be in this situation for the development situation that are not being reviewed at this point in time. So like Joe said, we're looking at a very small issue that could be a cog in larger issues in the future. So, all right. So the next step, the next issue.
Let me ask you another question. I'm sorry. I apologize. Let's put this into hypothetical land just for a moment. If a similar situation is presented to us, but instead of the Langford home, it's the Jones home, et cetera, and we do not approve this alternatives analysis, when the folks on the Jones home side go to seek a 61 home development, are they dead in their tracks, or how does the interplay work there? In other words, if we were to deny this in that situation, does that kill the 61 home development?
I don't know. I mean, they would probably appeal to the circuit court, and we would probably get reversed. But in the hypothetical that, where we don't get reversed, I don't know the answer to that.
Well, as I prefaced at the beginning, if we denied it, we would kill any development from 1 unit to 61 units.
Not on the alternatives analysis.
No, not in the alternatives analysis, but the actual, but the alternative analysis still kicks in, because there needs to be a different road. But maybe, like you're right, still, because there's an existing road now that breaks into Joppa Road. That road in its very existence, if we establish a buffer, is going through the floodplain, you would have to do the analysis for that road. Where Mr. Evans is getting more fact specific, a lot of the alternatives, their feasibility deals with where it's going for the 61 homes and things of that sort. So there are details that are interlocutory there. But all I do know this is, and this isn't before us, but from what I've learned, there needs to be an in and an out. There needs to be one job road in. So we can't eliminate it completely. Consequently, the road that is there for the Langford house triggers some sort of alternative analysis because it's going into the floodplain. That analysis itself may be different if there isn't 61 houses down the road, but there would still be some analysis that would be triggered due to the fact that it's not in compliance. So
One last hypothetical. That is all helpful to me, and I know this is not supposed to be educate Adam, but you guys have such an abundant knowledge on this stuff. So we're going to approve the alternative that is agreed upon in this presentation for the reasons that have been said. If at some later date, hypothetically, instead of a 61, for whatever reason, now it's only going to be 3, does that have to come back to us for a different alternatives analysis, or is there come back to us on this case? Is there a new procedure? And if I'm just getting too far afield, let's just move on. But I'm just really trying to understand how this plays into the future, whether this comes back to us if there's a change in the development plan.
I'm not going to say definitively. I have a thought. But I
Okay.
don't want to say.
You don't need to share it on the record. I can see I'm going a little bit too far, but I'm good with what we're going to rule and why. I do just find some of these things, because I'm very used to a different process working through the law than a lot of what is presented to our board and how it's done, and potential implications that aren't before us. And Joe has pointed that out, and I'm seizing on that to put it in greater context, but it's not before us what I'm proposing, so we don't need to address it.
Well, except I want to say that your point is excellent. And it harkens back to what I said earlier about how this feels out of place, out of time. It feels like the wrong time because we don't have the development in front of us. So if the development were to change significantly, then maybe the alternatives analysis were to change. My understanding, and I could be wrong, my understanding is once we decide it, it's done. It doesn't come back in the context of an ALJ hearing. I mean, it's done. That's my understanding. I could be wrong. Sort of hope I am wrong, but you know, as I say,
that makes sense. That's why you then felt compelled to at least to the extent you can state the desire to not be interpreted as endorsing the 61 home development, because your understanding is what we're doing is approving an alternative analysis that contemplates such development, and it ain't coming back to us if it in either way on that issue.
that's my sense of things. I could be wrong though, Adam.
I got you. Okay. All right. Sorry, Mr. Bell.
That's all right. It's okay. But just not to get too deep factually, a certain amount of homes is going to require a road split off the old road. Okay. I guess there's ways, maybe if there was one house, to be the same road, but there's going to be a critical mass. Some number of homes is going to require a road to be split off to those homes. How that road varies as to the number, I don't know if it would greatly vary because it's still going to be a road. So there's that. That's all I know.
No, I get it. And as back to where you started, we have the expert testimony before us. We don't have experts going in a different direction. We have Mr. McCann's cross of the experts presented. and we have arguments presented in a brief from Mr. Rosenblatt, but not Mr. McCann, and we're going to defer to the expert testimony that's presented to us, and that supports alternative number 5.
Yeah, again, and my only point here is if it was 3 houses, then the reason it was 3 houses, they arguably could go have a, ingress and egress on Mays Chapel Road. I mean, it was because of people on Mays Chapel Road objecting to the traffic associated with 61 houses that this alternatives analysis was pursued. Number 5 was pursued. That's why, as I say, I mean, the whole thing to me is a little confounding, but yeah, there would have to be an alternatives analysis, but if the development were significantly different, the alternatives analysis conceivably could be significantly different. So anyway, but it is what it is.
All right, the second is the road widening issue. We've heard testimony that the proposed development, it triggers the road widening. It's basically going to be required for it to be widening. We've heard testimony that there's going to be, I believe, 3 acres of on-site mitigation to kind of make up for any loss due to the road widening. Again, that was pretty much an undisputed decision. We heard the experts on that, and again, we have no opposition from another expert, so I really don't have much to say other than that I'm fine with it.
Yes, I agree.
Same.
And then the third issue of the sewer, so the older home now is going to be connected to the sewer line as well. There had been some discussions about where to put the sewer line. And then there were some discussions also about evidently the slope and the need for certain mitigations because gravity wouldn't carry the sewer line. What was, I think, the final decision was actually to, since they're going to do a new location for the road, as petitioners, as Mr. Canolis's choice of road, the old road is where they're going to dig the sewer underneath to minimize further encroachment into the buffer itself. So that was the choice that was made, since that was already a road and not in what would be the buffer. It's located in such that they were going to do it underneath the road itself, which seemed like a logical choice that was decided on by the county. Again, we've heard no testimony that contradicts that logic, so I'm fine with that as well.
Yeah, I think it's a driveway as opposed to a road, but
Yes, drive.
but yeah, and aren't they going to eliminate the driveway thereafter?
Yes, yes.
Yeah. So they're
that
going to put this under the driveway for the time being, and then later on they're going to eliminate the driveway. So
they'll eliminate the driveway, but I guess the thought is it's already it's already not a buffer, say, like growing things. It's a driveway. So
yeah. I mean, it's an interesting approach, and I'm happy to defer to the expertise of people who know about these things, because I sure don't.
All right, so they were the 3 that required the alternatives analysis. So basically, the testimony before us, and again, we're not affirming here. This is a de novo examination, so we're basically hearing the evidence ourselves. So basically, we are approving rather than affirming as to that situation. It was noted in materials presented to us that the depths had conditions for their approvals, things that they wanted to be done that were to be incorporated into the analysis. So I would suggest that any of those conditions that were previously discussed also be part included in our order for the compliance there too. So in summary, we have the request for the variance for the forest buffer we found practical difficulty, unreasonable hardship, so that in fact was granted. And then in 22-028, we have the request of the appeal of the alternative analysis that was previously approved, which we just reviewed all three of those in light of 33-3-112C and those three factors. And we found that we in fact prove those as well. So I believe that concludes the matter. We'll note in our opinion that 22-029 had been dismissed basically without opposition from the protestants due to the fact it was something that will be covered in the future during the development plan discussion. Is there anything further, gentlemen, that you would like to throw in the mix before we finish?
Not from me.
No, sir.
All right, gentlemen, it's been interesting. I'm sorry I don't get to stay and carry on with you today.
You can take my
Thank you for
place.
your excellent preparation and leading of the deliberation.
Well,
Again,
that I agree. I amen to that. Yes.
All right, well, thank you both, gentlemen. And Joe, if we have a couple minutes to see
Yeah.
yak about that other
Yeah,
thing.
we do.
All
Yeah.
right,
I'll give you a call. I'll give you a call.
All right, good to see you, Adam.
Good to
Okay.
see you, Joe. See you in a half hour.
Okay. Thank
Have a
you.
good day.
Yeah. Bye-bye.